Hello guys, and welcome to another episode of my lecture. This is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and this is another episode of Dieko Talks Law from the Dieko Daniels School of Law. And yes, today we will be talking about Maxim 7. Maxim 7 of the law of equity, which is the fact that delay defeats equity, or equity aids the vigilant and not the indolent. Delay defeats equity, or equity aids the vigilant and not what? The indolent. Yeah, in my last series of lectures, I have discussed Maxim 1 to Maxim 6. Maxim 1 being equity will not suffer a wrong without a remedy. Maxim 2, equity follows the law. Maxim 3, where the equities are equal, the law shall prevail. Maxim 4, where there are equal equity, the first in time shall prevail. Maxim 5, he who seeks equity must do equity. And Maxim 6, which is the fact that he who comes to equity must come with clean hands. I'm very sure that you should have, before you continue with this lecture, listen to all those lectures, because like I always say, that they are going to give you perspective and context for you to continue with this lecture. But if this is the first time of coming to my channel, I want to say a very big welcome to you. Please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video which is going to be of interest to you, like this one, you'll be one of the first sets of people to watch that particular video. Do not forget to also click the notification bell. It's very important, so that anytime I drop a new video, you are going to get notified on my new video. Also, you can like to follow me on LinkedIn at Diekolola Daniels. Thank you so much as you do so. So going straight into our lecture today, we are talking about the Latin maxim, delay defeats equity, or equity aids the vigilant and not the indolent. So let's go straight to the lecture. It is general principle that a person will not be granted equitable remedy if he is guilty of undue delay in bringing an action. Such delay is known as laches. Lord Camden, LC, in the case of Smith versus Clay, stated, a court of equity has always refused its aid to stale demands where a party has slept on his rights and acquiesced for a great length of time. Nothing can call forth this court's activity but conscience, good faith, and due diligence. I love what he said there. Nothing can call forth this court activity but what? Conscience, good faith, and what? Reasonable diligence. Where these are wanting, the court is passive and does nothing. Where what are wanting, where conscience is wanting, where good faith is wanting, and where reasonable diligence is wanting, the court will be what? The court will be passive and will do nothing. Now let's go to the next slide of the lecture. The principle governing the doctrine of laches were stated in the well-known dictum of Lord Selborne in the case of Lindsay Petroleum Company versus Heard. Now, what did Lord Selborne say? Lord Selborne said that the doctrine applies where it would be practically unjust to grant a remedy either because the party has by his own conduct done that which might fairly be regarded as equivalent to a waiver of it, or where by his conduct and neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation where it would not be reasonable to place him if the remedy were afterwards to be asserted. Now, the grammar is a lot, but it is not that much. This is it. The court is not going to intervene. The court is not going to do anything in two circumstances, according to Lord Selborne. Number one, the first circumstance is where the other party has relaxed has said, fantabulous, mo fẹ́ máa chill pẹ̀lú big coke, you know, at Fanta, at a little bit of pizza. They are doing something on your land, you don't care, you look the other way, you say, no problem. Or, you know, one thing or the other, you say, no, mo fẹ́ lọ chill ní Bahamas. And they are doing a lot of things on your land, and you decided not to say anything. Now, what Lord Selborne is saying is, where your act is such that it is to be interpreted as a waiver of your rights. You saw that they were doing something on your land. Instead of you to shout on time and say, hey, that's my land, you say, no, you want to go and take big coke. Fantabulous. Instead of you to shout, you say, no, you want to go and chill in the Bahamas, or you want to go and chill anywhere you want to go and chill. You did not see anything. First month passed, nothing. Second month passed, nothing. 6 months passed, nothing. 1 year passed, nothing. Lord Selborne is saying that where that happens, the law will interpret your quietness to be a waiver of your rights. That's number one. Now, the second part is saying, though perhaps not waiving that remedy, but yet put the other party in a situation. Now, what that means is where the court will not interpret your act as being a waiver. Maybe it took a lot of time, but maybe you were doing one thing or the other and you couldn't. But where it is going to be unfair and unjust for the other party if that remedy is granted to you. So, for example, you are coming to court and you are saying that the court should give you an injunction that the other party should leave your land because he has built on your land. Please, ladies and gentlemen, if you are the judge in that circumstance, how do you tell the other party to leave the land? Do you understand what I'm saying? He has built a whole house on the land, and now you are saying, Ogbeni, it be like say, I want me to come out. Now, as a judge, what do you do? This is where the Maxim seems to come in. Please, mister, I want an injunction from the court. What were you doing when this person was actually building on this land? Okay, this might not be a waiver of your rights, but it is going to be unfair on the other party for we to grant that injunction that that person should leave. Therefore, we have to look for another way. You cannot come under equity. Do you understand? Why? Because equity aids the vigilant and not the indolent. Do you understand that? And delay defeats equity. Now, further, let's go to what Ademola CJN, that is the Chief Justice of Nigeria, said in Fagbemi versus Aluko. Now, he said that in considering the equitable doctrine of laches, the court does not act only on the delay by the plaintiff, but must also consider acquiescence on the plaintiff's part and any change of position that has occurred on the defendant's part. Now, that's what I was telling you about. Now, it is not only the delay you should look at when you are looking at this doctrine. Look at the fact that the delay is accompanied with knowledge. Delay plus knowledge is equals acquiescence. The delay, okay, for example, a man has been sick for the past 3 years. He has been going from France to Germany to go and see top specialists and, you know, stuff like that. And then at the end of the day, he got back and got better. He then came back to Nigeria and then he saw that someone has built on his land. Now, there has been a delay, but there has not been knowledge. Therefore, there cannot be acquiescence. Are you listening to me? For you to have acquiescence, you must have a delay accompanied with the knowledge of what is actually going on. You knew that this thing was going on, yet you delayed. It is equals to acquiescence. So, you know, certain things might actually go on with the plaintiff in this case, coming to court seeking equity. So the fact that there has been a delay does not necessarily mean that there has been an acquiescence. And that is what, you know, Ademola, Chief Justice of Nigeria, is saying in the case of Fagbemi versus Aluko. He is telling us that not only are we to look at the delay by the plaintiff, but we must consider acquiescence. We must consider the fact that that delay must have been accompanied with knowledge. Do you understand that? And secondly, any change of position that has occurred on the defendant's part, which is what I'm telling you about. Now, it would have been even more easy if, as a judge, there is somebody coming seeking equity, and maybe there has been delay, but there is no acquiescence, and the other party has not built on the land. There is no problem, this is it and all that. You can easily decide. That is why that other part, any change of position that has occurred on the defendant's part, but now the other party has built, the other party has even started living. This man he was sick actually. There is no acquiescence. He was sick, he didn't know, because nobody was there to tell him. Everybody was trying to make him better. And this land we are talking about is one at one village like that you barely find people there. So unless he goes back there during the holidays around that December period, he wouldn't know what is going on. So there is actually no way he could have known. And since all his family members are trying to make sure that he gets better, nobody went back to the village to know what was going on. Do you understand that? So now there has been delay, quite all right, but there has been no acquiescence. But this other party has already changed position by building on the land. So what then do I do as a judge? Do you understand that? So these are the things that you consider under this maxim. But now I think it is time for us to look at certain cases. First, so there will be laches where the plaintiff has so acted as to induce the defendant to alter his position in the reasonable belief that the claim has been abandoned, or where the delay amounts to evidence of an agreement by the defendant to abandon his right. Now, for us to explain that, let us explain it with the case of Agora versus Olushi. The case of Agora versus Olushi. Land held by a family under the customary law sold in 1902 to the defendant by certain members of the family without the consent of the plaintiff, whose consent was necessary for the validity of the sale. Now, I know that if you are not too strong in land law and customary land tenure system, you will not understand what is going on here. Now, in our day and time now, what we have is Land Use Act, certificate of occupancy and all that. So I am the owner of my land. When I want to sell it, I just look for any other buyer that is serious. I give him my C of O, he gives me 10 million naira, and land sold. We do the whole agreement, write it down, sign deed of assignment and all that. But in the olden days, as you can see, 1902, the land tenure was usually held by the family and not necessarily by an individual. Do you understand that? Land was held by what? The family, and not necessarily by individuals. Now, going by that, it means that for a land to be sold, if a family wants to sell a land, it means that all the principal members of that family must sign. Are you listening to me? Principal members and the family head. Where the family head does not sign, but the principal members. Who are the principal members? A man now gave birth to 4 children. Those 4 children are the principal members of that family, because the family property is governed by those 4 children, but the first son is the family head. Now imagine that the second, the third and the fourth signed the document, but the first son did not sign. What that means in law is that the agreement is void. It is not existing. It is unenforceable if the first son does not sign. But if the first son signs, but the second son or the third son or the fourth son does not sign, it is a voidable transaction. Voidable means that it is not enforceable until that person signs. There's a difference between void and voidable. Void means that you can't enforce it at all, even subsequently after that person has signed. But voidable means that it can only be enforceable after that person whose signature is missing has signed. Do you understand? This whole thing that I'm saying is under land law, and the case, the authority for this principle is the case of Ekpendu versus Erika. But we are not teaching land law today. I am using this to make you understand what is currently going on here. So I'll read that intro for you again. Now, land held by a family under the what? customary law sold in 1902 to the defendant by certain members, but without the consent of the plaintiff, whose consent was necessary, that is, whose signature was necessary for the validity of the sale. Now, we are saying that the plaintiff here, we don't know if it is the family head or if it's just a normal principal member, but the next line will give us something. Now, the next line is telling us that the sale was therefore voidable by the plaintiff, which automatically tells us that he is not the family head. He is therefore one of the principal members. So the sale is what? Voidable. Voidable means that the sale is not enforceable until the plaintiff signs and gives consent. Now, the plaintiff took no step to set aside the sale until 1905, 3 years later. After that particular transaction in 1902, it's 3 years later that he came to court. That's when he commenced this present action. Now look at the things that the court found. The court found that, number one, the plaintiff had at one stage agreed for a consideration, that means agreed for money to ratify the sale, that means to sign, but he subsequently rescinded the agreement, which means that he did not collect the consideration and he did not sign. Now, number two, that the defendant had at one stage sued as owners of the land to eject trespassers, and the plaintiff knew of this but did nothing to interfere. What does that mean? It means that the defendants, the people that they sold the land to, on a normal day, they are not even the owner of the land, because that sale is unenforceable by the court. But the plaintiff has so slept on his rights that even when they came as owners of the land to the court to eject certain people that were trespassing, the plaintiff said nothing. He did not interfere, which means that automatically the plaintiff is already recognizing them as the owner of the land. Because if it's my land and someone else is standing as owner to eject certain people in court, chairman, but who give you local standard? You are not even the owner of the house in the first place to be standing as owners in court. But the plaintiff the plaintiff said, well, me, I have other things to do. I want to go and drink cold zobo. You people gonna be fighting in court. As for me, I want cold zobo. Now, getting to number three, the defendant had erected houses on the land while the plaintiff did nothing to stop them. What was the plaintiff doing? Drinking cold zobo. Now, when the cold zobo finished 3 years later, which is in 1905, he now came to court and said, oh yeah, my lord, you see that sale of 1902, it is voidable, and since I have not signed, it is unenforceable, and I want to remove them from the land. The court held that all the circumstances, which means that we are not only looking at the delay, we are looking at knowledge, we are looking at the fact that the plaintiff has also built, we are looking at the fact that the plaintiff has also taken steps to change his position. We are looking at everything. All the circumstances now coupled with this 3 years delay in bringing his action amounted to laches, and the plaintiff lost his right to set aside the sale, because on a normal day he can naturally set aside the sale because the sale was voidable. But instead of him to come vigilantly to court to set it aside, as equity will only aid the vigilant and not the indolent, he was drinking what? Cold zobo. And then at the end of the day, after 3 years, and when the defendant has done a lot of things on the land, the court held that he could no longer set aside the sale. So we go to our next case, which is the case of Ziako versus Abutu. Ziako versus Abutu. A in 1947 was granted lease of a plot of land by B. Now, in 1947, B gave A lease to a plot of land. What does lease mean? Lease doesn't necessarily mean that you are the owner of the land. A lease only means that you are a tenant. Do you understand? So for example, you want to get a house in Lagos and all that, or this 1 year agreement, those are what they call leases. But there are certain long leases, like 10 years kind of leases, 20 years, 30 years kind of leases. So for example, if I want to build a refinery and the land is a very large land, but the owner of the land does not want to sell the land, he can give me 100 years lease on the land. 100 years lease on the land, and yes, that lease is going to be very enforceable. So in this case, B leased a plot of land to what? To A, 1947. Now C came and said that that same plot of land was given, that means formed the subject matter of a grant by B's predecessor in title in 1942. Now, I want you to understand this. What does predecessor in title mean? It means the person that gave you a title. So if I'm the owner of the land and I sold my land to Gbadebo, I am the predecessor in title of Gbadebo. Do you understand that? And if Gbadebo sells his land to Shade, Gbadebo is the predecessor in title of Shade, and Shade is the successor in title of Gbadebo. Do you understand that? So now, in this case, C is alleging that B's predecessor in title, let's say B's predecessor in title is X. X had given him that land in 1942. That is 5 years before B gave the land to A. Are you listening to me? B gave the land to A in 1947. But C now came and said, no, why will you give the land to A in 1947? You that you are even giving the land, the person that gave you the land, that is Z. B, you, the person that gave you the land, Z, already gave me the land in 1942, 5 years ago. So which means you A, you B, you people don't have right to the land. I am the one with the right to the land. Now, what did the court hold? The court held that if C's allegations were true, and if C could prove that A had notice of C's interest where he acquired the lease, which would prima facie mean that C will be entitled to a degree of specific performance. But since he took no step to enforce his right until the present action in 1954, even this C smoked some kind of, I don't know what he smoked, but he's on something. How can something happen to you? They gave you lease in 1942. Someone else collected lease in 1947. Look at the time you are coming to court, 1954. You are not coming in 1954. That's how many years? 3 plus 4. 7 years after they granted the lease to A. 7 years after. Like, I mean, no court is going to want to even come to your aid in that kind of circumstance. So the court is even telling C that, let us even imagine that A knew that your interest actually exists. Let us imagine that A knew, because you know that there is doctrine of notice, which means that if A did not know that C had interest, then A can carry the land. But let us imagine that A knew, which means that your own interest will be prioritized because A has knowledge. I think I've taught you this under Maxim 3 and Maxim 4. The first in time and the law will prevail. I taught you that. So let us say that A knew of C. Do you understand? Which will automatically mean that C will be prioritized. Let us prove. Although there is no proof that A knew, but let us say A knew. We still cannot help you, because you took about 7 years to bring this action from 1947 to 1954. We can't help you. The court held that C was guilty of laches and had therefore lost whatever rights he may have had. That was what the court held in the case of Ibe Ziako and Abutu. And then Reynolds J quoted a passage from Hansbury Laws of England, where he stated that in certain classes of claim, the claim of relief in equity must be made with certain promptitude. In claims of specific performance and for the rescission of contract, the special relief in equity is only given on condition of the plaintiff coming with great promptitude. Any substantial delay after negotiation has terminated, such as a year or probably less, will be a bar. Can you see that? There must be what? Great promptitude. Great promptitude when you are, coming to court. Now, but the doctrine of laches is certainly not restricted to specific performance and rescission of contract only. In the case of Ephraim versus Asukwo, the plaintiff sought to have grant of letters of administration set aside. What are grants of letters of administration? If a person dies and he leaves a will, the person who is supposed to carry out the terms of that will have to go to the probate to get letters of administration. It is upon that letter that he acts to distribute the will. Now, the plaintiff is coming to set aside the letter of administration that has been granted to another person to distribute the will. Maybe they were supposed to give him something and then he did not get that thing, so he now wants to stop those people that are distributing the will by setting aside the letter of administration. The court held that it is nearly 2 years. Brother, they don't grant letter of administration since 2020. You are now coming in 2022 to institute an action to set aside the letter of administration since 20. They cuckoo would have finished sharing the property now. If they've granted letter of administration since 2020, they would have, shared the property now, because once you have letter of administration, what is the next? Hey, alaye, he gave you his car, take car. He gave you his house, take house. He gave you his clothes, take clothes. I mean, do you understand? The court held that as nearly 2 years had elapsed since the grant, and the administrator had in all probability completed distribution of the estate, there has been laches and the plaintiff claim failed. I mean, it is only reasonable. That's 2 years ago. What were you doing? Drinking zobo since 2 years ago, cold zobo. Now the zobo has finished, your eye have clear. You're now saying that you want to come and set aside something that they granted 2 years. I mean, it doesn't make any sense. In fact, after they finish granting it, 6 months after, 1 year after, is already too long, because it will take the administrators about a month or 2 months to share the properties. It's not a big deal now. Hey, take key to car, you take land, then they sign documents and all that. It's not really actually a big deal per se, so I don't know why you would take at least 2 years when property had almost been shared out with the members and all that. So let's go to the next slide of our notes. Now, any reasonable explanation for the delay, such as the plaintiff's ignorance of the fact which the claim is based, infancy or other disability of the plaintiff, or fraud on the part of the defendant, we absorb the plaintiff. I think I said this already. Let's start with ignorance of the fact of which the claim is based. For example, the guy who is sick, who has gone to France, Germany and all that, and he doesn't know what is currently going on in the village where he bought a land. In that case, he's totally ignorant. Now that can absolve the plaintiff. There can help the plaintiff even while in court. My lord, I have been here, I have been here, I have been here. Show the medical whatever it is. I did not know. That makes sense. Or where there is infancy. Infancy means that maybe the guy was 12 years old when the other party started building on his father's land and his father is dead. He didn't know what was going on and all that. 10 years later, or when he's old enough to bring up the action, he will not be guilty of laches, because obviously, do you expect a 10-12-year-old boy to be in court? No. Or disabilities on the part of the plaintiff, or fraud on the part of the defendant, we absolve the plaintiff. So now, also in relation to actions concerning rights to land, the right of the present plaintiff over the land will not be affected by the laches of a predecessor in title, as held in Nwankobi versus Nzeku 1964 1 WLR 1016. What does that mean? That tells us that if the predecessor in title, I already explained what predecessor in title is to you, the person who came before you in terms of title. So I told you that if I'm the owner of a land, I saw somebody doing something on my land and I did not say anything, and I then transferred that land to someone else, my laches, me not saying anything, me being ignorant, or me being whatever it is, will not be transferred to my new successor in title. Do you understand? Look at the rule again. In relation to actions concerning rights to land, the right of the present plaintiff, that is my successor in title, Gbadebo, over the land will not be affected by the laches of the predecessor in title, which is me. Do you understand that? And that is the case of Nwankobi versus Nzeku. Now, lastly, statute of limitations are applicable in all states of the federation. Action becomes statute barred once the stipulated time by the relevant provisions for each cause of action has expired. What that means is, once a time for which you can bring action has expired, there is nothing you are going to tell the court. It has expired, it has expired. For example, for contract, after a case has arisen, let's say something happened, breach of contract, from the day the breach of contract started to the next 6 years, after 6 years you cannot bring an action on that contract anymore. The statute of limitation for contract is 6 years. The statute of limitation for land agreement is 12 years. Where there is a problem, a dispute on a land agreement, you have 12 years to bring that action. If you don't bring it in the next 12 years, boom, that's the end. They are going to bar you from bringing the action. So once you just enter court, if I'm the lawyer on the other side and you are the lawyer shouting, my lord, you know, whatever it is that you want to shout in equity, equity will not suffer a wrong, my lord, without a remedy. Just my lord, I would like to, show opposing counsel in this case that equity will also avail only those who are vigilant. And my lord, I don't know how well the opposing counsel knows how to count, but I think we have used 12 years and he did not bring the action. If that does not define indolent, if that does not define being unnecessarily ignorant, my lord, I don't know what else will. And therefore, please, my lord, I would submit that you strike out this action, because now play we can't play for here. So do you understand what I'm saying? So to say, if it's more than 12 years and the other party brings the action after 12 years, then statute of limitation will say it has expired, no more action. Now, in determining whether an action is statute barred, the question must be asked, when does such time begin to run? And this was stated in the case of Board of Trade versus Keina, Ivin and Co Limited. Now, for those who are mutters, that means for those who moot a lot, this is a very lucrative area for questions most of the time in mooting, because they will bring you disputes. One of the issues in those disputes is that it is statute barred, and you have to argue, especially when it is against you, you have to argue that it is not statute barred, that you can still bring the action. And then the rule is, in this case, Board of Trade versus Keina, Ivin and Co Limited, which is why I tell people that the best lawyer is not the person that knows all the law, is the person that knows where to find the law. I think Lord Denning said that in the case of Parker and Parker. You don't need to know all the law in your head. All the cases that I've been teaching, I cannot even remember most of them when it comes to the cases, but you see the principle, I know them. Where do I find them? I know that. Do you understand? So if I just say statute bad, what is the principle, what is the case? I know where to find it, and this is where to find the rule to use when an action is said to be statute bad. Now, the answer is that time therefore begins to run when there is in existence a person who can sue and another who can be sued, and when all the facts have happened which are material to be proved to entitle the plaintiff to succeed. Three things: a person who can sue, 1; a person who can be sued, 2; all the material facts which were entitled to plaintiff to succeed has also happened. Where those three things, then yes, you can bring an action. If the day where that starts, just start counting it to 6 years, that day on the 6th year is the day when the action become statute bad. Also see the case of Fadare and others versus the AG of Oyo State, 1982, NSCC 52 at 60. And with that, thank you so much for watching to the end of the lecture. Make sure that you subscribe, like and share this video with your friends. My next lecture will be on the Maxim, Equality is Equity, and I would love to see you in my next class. Do not forget to follow me on LinkedIn at Dear Kolola Daniels. See you in my next class.